Hello and welcome to the BRR Legal Brief, where we bring you the latest legal issues affecting businesses in Australia. Today we're looking at the industrial relations system following the 7-day strike at BHP Billiton mines in Queensland. Joining me to discuss is the Head of Workplace Relations and Safety at Middleton's, Alice DeBoos. Alice, welcome.
Thanks very much for having me.
Now, Alice, it's been one of the largest strikes that we've seen in a decade, with 3,500 workers walking off the job. What have been some of the issues in this dispute?
This is essentially an old-fashioned bargaining dispute. These workers and their union are in the process of negotiating their new enterprise agreement to run for the next 3 to 4 years with BHP in Queensland. There'll be, no doubt, from both sides, a very long list of issues. But essentially what we have at the heart of it is the union and its members seeking to insert a number of clauses into that agreement, or those agreements, that BHP is just holding firm on and saying, no, we need the right to manage our business the way that we want to manage it, and we're simply not prepared to give away those flexibilities. So that's what's at the heart of it. It's a bargaining dispute. It's two parties trying to come to an agreement. So far, they've been very unsuccessful at doing so.
Yeah, certainly. And not only have we seen BHP, but a number of industrial disputes in the press. Do you think we're seeing an increase of industrial disputes recently?
I think it's very hard to say. I think in general, yes, there has been an elevated level of industrial activity lately, but I also think it's fair to say that the industrial disputes that we've had are simply gaining a higher profile than perhaps they might have in the past. We had the very big Qantas dispute, which again at its heart was a bargaining dispute. Because of the press that got and the press that the Fair Work Act review is getting, I think that any dispute that involves enterprise bargaining is going to stay in the headlines. But at the same time, industrial relations and industrial disputes are seeing a lot more activity in terms of what we see day to day as industrial lawyers. We're seeing a lot more of these issues come up than have done in the previous few years.
And Alice, you just mentioned Qantas. Obviously, we saw Qantas ground its fleet. Maybe it has more capacity to do this as a large employer. But what about for smaller employers? How are they faring under the current system?
I think it's the smaller employers who are having grave difficulty with a lot of these enterprise bargaining laws under the Fair Work Act. The difference between a small employer and someone like BHP or Qantas is that BHP or Qantas can afford to take a hit, to lose some money, to stand on principle about what they do and don't want in their agreements. I think that the Qantas dispute, some estimates say that cost them $90 million. Well, Qantas, that's a lot of money for Qantas, but they could obviously afford to pay it, whereas many small employers are simply not going to be able to sustain that level of damage to their business, and as a consequence will give in to these types of demands far more readily than a larger employer might.
And just, I guess, looking at the current state of industrial relations and the fact that, you know, some employers may have to give in, what about if we compare with, say, work choices? Do you think that employers are now hoping that we might see some changes to the Fair Work Act following the review?
I think that there are those in the business community that will certainly hope that we see some changes following the Fair Work Act review, but I would not be too optimistic. I think that the Fair Act review is quite limited in its scope, and I don't think that there's going to be an enormous number of changes, particularly to the enterprise bargaining rules that come out of the review. And largely, that's due to the fact that most of the enterprise bargaining laws are those that were introduced by the Howard government. So they have a lot of work choices has been replicated in the Fair Work Act. Parts have changed, definitely, and it's those parts that have changed that are causing problems. And that's mainly around the process of bargaining and what you can actually bargain about. And they are really fundamental issues, and I cannot see the government at this stage in the electoral cycle seeking to change that statute.
Okay, and just, I guess, finally, maybe government doesn't want to change the statute, but what about for employers? Are there any changes that they would be hoping that will come through to the Fair Work Act as it currently is?
I think that there are really 2 to 3 key areas. The most key area I think that employers would like to see change as a result of the Fair Work Act review is around enterprise bargaining. So those rules about how you bargain, when you bargain, who you bargain with and what you can bargain for are key problems at the moment that employers will be hoping to see some changes to. But there are other ones that perhaps don't get the headlines but cause as many problems. Things like the transfer of business provisions that were introduced into the Fair Work Act a couple of years ago. These really cause particularly large organisations some real difficulties with outsourcing and insourcing and restructuring of their employees. It would be great, and I think that a lot of businesses would be relieved to see some changes to those laws as well.
Well, we're still obviously waiting on the Fair Work Act review's recommendations, and I'm sure many people will be interested. But Alice, thank you for joining us today.
My pleasure. Thank you.
And viewers, thank you. We hope that you can join us for next week's Legal Brief.